We need to show people that the new type of structures work better in order for people to want to change. People are, in general, I would say, very, very conservative. The fact that they use a cell phone says very little about the ideas that they have in their heads. Uh, People are still immersed in the reductionist paradigm of cause and effect and very closed systems, and not into open systems. They're not into holistic ways of thinking. They still think that all logic is based on Aristotle, the syllogism, and that's pretty uh, good for them. I've asked in my conferences or chats with attorneys what type of logic goes into the law, and most of them, those that do answer, say, well, it's Aristotelian logic, it's the syllogism. If you know, the famous all men are mortal, Socrates is a man, then Socrates is mortal. Of course, that goes into every law book in the sense that if you do this, then this happens. Since you've done it, then you can apply the consequences. And that's as far as many, even attorneys, will think. And when you say, how is circular logic involved in the creation of law? And they don't even understand the question. And you say, well, the whole legislative process is a circular logic scheme, and it never ends. That's why it's circular, because you can approve a law for telecommunications, and next year or 5 years from now, you're going to change it. Why? Because there's new technologies and new ways to reorganize the technology sector. So it's most of the law implies a circular logic that you solve problems by approximation. You never solve the problem completely. You sort of go as far as the circumstances will allow. But the fact that lawyers do not understand this is very worrisome.
I think you're echoing in this respect something that I've always said. In England, and I gather in the Napoleonic system as well, you have this theory of stare decisis. You're bound by prior decisions that are made. That's how the law evolves. Somebody states what it is, and the next person who has the problem is bound by the decision that the judge reached, in whatever, maybe 2 days ago or 200 years ago, but stare decisis. That's the greatest sin of the law, because it perpetuates past mistakes, for one, but it doesn't allow the law to take into consideration changing circumstances. And what you're saying is, you're right, there is a circular logic, but stare decisis is there, so to speak, to impede the operation of that logic. Because once Judge A said it in 1760, then it becomes binding on all lawyers, on all judges who come subsequently. It's a very illogical, unreasonable, close-minded attempt
Well,
to
you and I know that this sort of rule is a way that the legal system, that the jurists try to satisfy the idea of what we call in cybernetics requisite variety. You're trying to have rules that will solve every imaginable problem. And one way to try to do it is say, once you find a solution, everybody has to apply the same solution. But you and I know that this is not enough. Now, in the Napoleonic system, we do not put the emphasis on the legal precedent. Our laws are created through theory, okay? Through a very general scheme, very abstract scheme that starts building this structure until it gets to the requisite variety situation. The Saxon law, the Anglo-Saxon law, says no, let's go to the street level, started this decisis law or rule, and we will be getting to the bottom of things immediately. So this is what I would say are is the main differences between the two legal systems. One is based on conceptual structure, and the other is based on the practical stuff, the everyday stuff. And you and I know that you have to work from both ends, okay?
Exactly. Neither of them works alone.
Absolutely.
But if you combine the two, then you have the beginning of something that truly can make sense.
Because we have to look at the whole system. We have to look at what the system is doing. Now, a friend of mine, a professor from Loyola University who died just a few months ago, Robert Benson, wrote a book called The Interpretation Game, where he exposes the system and he shows that this Anglo-Saxon system, the way it's been working in practice, has a universal constant behind it, which is to increase the income of attorneys and judges. Okay? This is the key variable that explains the evolution of the system. Okay?
I got to, you know that I am a judge or a part-time judge in any event. I find that thesis, I see that played out day in, day out in my court when lawyers appear before me. Lawyers have a way of extending everything, complicating everything, instead of addressing the matters that have to be decided in a particularly conflict that comes before me as a judge. I in some ways regret the way I feel about my profession. But you're absolutely...
But we don't have to feel guilty as attorneys. We don't have to feel guilty. We have to just look at the system, and we have to make sure that there are no rewards being offered for these behaviors. And the fact is that as attorneys, we could, let's say, produce more justice and still be well paid. And we don't have to play tricks on each other in order to, satisfy the desires of our clients. The adversarial system assumes that if we're contending with one another, justice will be done. Justice will find the equilibrium. And it's absolutely not true. This is another assumption that is totally mistaken. We could do more through some sort of cooperation, and we have to study that new system and come out with suggestions on how to do it. If the system is rewarding lawyers for, making all these claims when they shouldn't, then let's get rid of the rewards. You cannot have a system with all these rewards and expect the attorneys to do something else. Okay? Maybe the problem is that the attorneys should not be the ones designing these systems. Maybe it should be just the common folk. But then the common folk don't know about law.
That's exactly what I'm saying. The lawyers know how to play the adversarial system for all it's worth. The assumption of the adversarial system is flawed, as you have said, on its own. When I have cases before me in which there are no lawyers representing the parties, and some of them are very complex because I sit in a people's court, but when I have no lawyers before me, I act more as a facilitator, a conciliator, than I do as a judge in the traditional sense. We cut through all the bullshit, because a lot of it is bullshit that lawyers usually generate, and we get to what the issues are, and we resolve them by seeing, well, how can we make things work together better instead of apart, which is the objective of the adversarial system. We get better results. I know we get better results because when parties walk out of my court, quite often they're quite happy with what has been accomplished, the way in which the conflict has been addressed and resolved. And we have all sorts of avenues open on that basis that are not open to lawyers working within the framework of the judicial system as it now stands. Yes, for whatever it's worth, it's much better when people do not profit from the delays and the intricacies of the legal system. And I see that every day in my court.
Well, we know for a fact, because I worked at doing a new procedural code here in Monterrey. We never did, it never got approved, of course. It was too modern and too good to be approved. But what I learned studying for how to build a new procedural code, I came to the conclusion that we're following procedures that were established in Spain in the 13th century. That's basically the way things are structured right now.
In the English system, by the way, it's Magna Carta, so it's in the 11 or 1066 or thereabouts.